Supreme Court to hear Obi's appeal against presidential election petition court ruling that upheld Tinubu's victory at the polls on Monday. Bola Tinubu appoints new director generals for NOA, NBC, NTA, and ARCON. Appeal court reinstates sacked Lagos Labour Party lawmaker Seyi Shomi. And outside Nigeria, 9 arrested for vote tampering in Liberia. And Congolese protests against East African force. It's Kofi. Bartels Politics HQ starts now. You're welcome. After presenting fresh evidence against President Bola Ahmed Tinubu, the presidential candidate of the People's Democratic Party, Alhaji Atiku Abubakar, has asked the Supreme Court to overrule the president's electoral victory. Atiku had filed a fresh evidence against the president some days ago. All right, he hadn't filed fresh evidence, actually. He had made an application for leave to file fresh evidence after it emerged that President Tinubu had some sort of certificate saga. We know what had happened there. Nigeria's Supreme Court faces a historic moment in the country's political history, or landscape rather, as all eyes are on the justices of the Court of Appeal. Well, joining us tonight to look at, of course, the fresh developments in this case, we have legal practitioner Liborous Oshoma. Good evening to you, Liborous. Thank you very much for your time.
Always my pleasure. Good evening.
All right. Liborous, the development is that Atiku Abubakar, through his lawyers, has written to the Court of Appeal asking it not to go the way of technicalities in his application for leave to present fresh evidence in his appeal. Help us understand the legal processes at play, because Atiku Abubakar had initially approached the Court of Appeal seeking to overturn the decision of the PEPC. We know that. We know he made an application for leave to present that fresh evidence in his case against the president. And the president, through his lawyers, filed a brief of arguments. Now he's writing again. What's going on? It's a bit somehow hard for ordinary people to really keep track of what's going on. So help us, please.
Yeah, thank you. You remember recently the Chief Justice of the Federation said that social media sentiment can never take the place of hardcore evidence, and that the courts do not decide on the basis of social media and sentiment. And then what Atiku basically is trying to do is to whip up those sentiments that the court says they want to depart from, and then also to whip up, to ask the court to actually rely on technicalities to deal with his matter, because it is only technicality, really, that would make the court to depart from its own rules, from the laws laid down, and from the way, the modus operandi of taking evidence at the highest court of the land. So let me break it down, basically. From the brief of arguments filed. At this level, when the matter is on appeal, at the court of first instance, the petition is filed. Once a petition is filed, a respondent will file their respondent's, a response. Then the petitioner will file a reply to the respondent's response. So at that stage, pleadings would have been completed. And so, when the Court of Appeal said, look, new issues raised in the reply brief, what the court did is to expunge those new issues raised in the reply brief, because a reply is supposed to contain a reply to the issues raised in the respondent's response. That if you now begin to raise new issue, the respondent no longer have opportunity to reply again, because we say there should be an end to, the back and forth in court. Also, when a matter goes on appeal, you file your notice of appeal. The issues you are going to argue at the in your brief will be distilled. Like we say, we distill from the notice of appeal. The issues will be drawn from the notice of appeal. The notice of appeal is the bedrock, is the foundation of your appeal. All of the issues that you are going to submit before the court for argument will be drawn from your notice of appeal. It is like your statement of claim. So any issue that is not in your notice of appeal cannot be argued in your brief. And any issue that is not in the notice of appeal, except there is a cross appeal, cannot be argued in the respondent's brief. In this case, there is appellant, who is Atiku now, has filed the appellant brief. And the respondent has responded. In the appellant brief, there is no mention of the certificate issue or issue of qualification. In the respondent brief, they responded to the issues that have been raised. Now, you are asking court to grant you leave to bring in fresh evidence. Are you going to argue? Are you going to file another brief of arguments? Is the respondent also going to file another brief to respond to these fresh issues, considering the fact that they were not contained in your original brief? And the court has till, I think, 11th of November to deal with this matter. So when you put all of this together, the court, by the rules of Electoral Act, the Constitution, and the practice direction, the court is time-bound and the court has procedures that they follow. So what Atiku is now asking is that the court should depart from its procedure and use technicality now, maybe what you call a doctrine of necessity, to allow him to open his case again and take arguments or take witnesses and begin to prove issue of forgery at the Supreme Court. And I really don't know how he wants to do it, but I want to see the magic that his lawyers want to perform, and I would love to learn that magic.
All right, you call it magic, quite interesting. We'll get to more of that in a moment. But without Liborous, without attempting to plead the case of any of the parties in this matter, and generally speaking, we're all here for enlightenment, and which you're so eloquently doing for us. Where do you stand on the issue of admissibility of fresh evidence by the appellate court? You touched on that a bit, but I want your overall precise opinion on this, generally speaking. Now, some have argued, including some of your colleagues, that this is very rare as far as this court process is concerned.
Yeah, it has nothing to do with where I stand. The question is, where does the law stand? Where does the law stand on this issue? The law allows fresh evidence if at the trial stage that evidence was pleaded, but it was not in possession of the appellant or the petitioner at the trial stage. And so on appeal, you are now seeking leave to bring this fresh evidence because you had pleaded it, you had laid foundation for it, you had led argument, led evidence in support of that, but as at that time, it was not in your possession. But in this case, it was learned that Atiku brought in this evidence in his reply. He brought in this piece of evidence in his reply, even though he abandoned it subsequently. And like we say, evidence abandoned in court goes to no issue. That it was abandoned subsequently. And now, on appeal, you suddenly realize that, yes, you have found that missing link that you are looking for. From the face value, is there anything extraordinary that will make Supreme Court admit this piece of evidence? That is left for the Supreme Court to decide. Also, exceptional circumstances. When you plead exceptional circumstances, some of the exceptional circumstances are what I just explained to you. That is ground for Supreme Court admitting fresh evidence. But in this case, and then also, it must be contained in the appellant's brief of argument. In this case, appellant had filed their brief, the respondent had responded. It was not contained there. The argument was not contained there, except the argument is there. And then you now say you want to bring in the brief, the piece of evidence. If the argument is not there and the evidence is admitted, there is no argument in support of that piece of evidence, it will also be deemed as a piece of evidence that was just laid on the court and there was no argument, no life was breathed into it. You seek for leave to admit the evidence, and then what does the law do with it when your brief has been filed? So there must be exceptional circumstances under which this piece of new evidence must be admitted. And also, some of the exceptional circumstances, like I said, is the fact that you have pleaded this document, you have led evidence in support of it, but that you couldn't lay your hand on the evidence as at the time that you pleaded it and you led evidence in support of it. In most cases, for example, you have, let's say, photocopies, certified photocopies of this document, and you had put them in. All you just needed is this document from the university to authenticate what you had put in. All of this evidence, unfortunately, had been with the appellant at this stage, in this case, but I do not really know why they didn't push them in, at the court of first instance. And now, rather than concentrate on the matter in court, you are busy issuing press releases and addresses, and you're addressing the Supreme Court outside of the court. And I really wonder how the Supreme Court is going to deal with that.
Interesting, Liborous. It's making for an interesting, well-poised legal battle, and I think by the end of the day, all of us will be better informed for it. But I want us to look at the, we just flashed on the screen Atiku's motion, notice of motion, so we can refer to it whilst we are going on. But Atiku Abubakar predicated his motion for leave to file fresh evidence against Bola Tinubu on Order 2, Rule 12, Sub 1 of the Supreme Court Rules 1985, Section 137, Subsection 1 of the 1999 Constitution as amended, or the Constitution of the Federal Republic of Nigeria as amended, as well as the inherent jurisdiction of the Apex Court, as encapsulated in Section 6, Subsection 6A of the Constitution of the Federal Republic of Nigeria, 1999 as amended. Now, please, I know there's a lot we don't, to unbundle right now, but as much as you can, because we didn't prepare you for this, help us understand some of these laws and statutes, that we're talking about.
Yeah, you don't have to prepare me for it. This is what I do every day.
All right.
Job at school.
Okay.
Order 2 of the Supreme Court is what is the order that allows the Supreme Court to grant leave to a party to bring in fresh evidence, provided exceptional circumstances is shown, not just pleaded, exceptional circumstances is shown why that piece of evidence was not admitted at the lower court. And then Section 137, subsection 1, deals with the qualification for becoming the president of Nigeria, and that if you have submitted a forged certificate or document, and then you are disqualified from becoming the president of Nigeria. So that's basically what that section says. And then inherent jurisdiction, inherent powers of the court. That's the power domicile, the power residual in the court. And so that's basically what he's saying. Look, even if I don't plead the specific orders or the specific provisions of the law, but the inherent power that is residual in you by the powers vested in you in Section 6, subsection 6 of the Constitution, grants me this request to bring in this fresh evidence. And so that's basically what that application is. Mind you, I need to also state this. Leave to filing fresh evidence is different from filing in fresh evidence. You first and foremost need to seek leave to file, and then you now file. To file and then to deem what I have filed as properly filed and served. The fresh evidence I have filed as properly filed and served. So these are all of the prayers. But the first thing is to admit the fresh evidence. The second thing is what the court does with that evidence. Whether that evidence amounts to proof, whether that piece of evidence amounts to proof of forgery or not, is another issue, another hurdle that the court will need to look at, because it is one thing to say, this is the document that I got from so-and-so place. It is another thing for the court to say, this document substantially has not proved any allegation. I also, because if you go further in that motion, they cited the case of Ada. So please permit me to quickly breathe life into that case for the benefit of our viewers. In that case, in the case of Ada, Ada contested for, I think, Utukpo House of Representatives seat or so, sometimes in 2011, and then he was alleged to have submitted a forged certificate, and the tribunal in that 2011 held, was it 2011 or 2015 or so, in the tribunal held that he did, the police investigated that certificate, and the registrar of that university, I think Polytechnic in Mubi, was at the tribunal to testify that indeed this person did not graduate from their university. And so on that ground, the man was disqualified from the seat. He was, his election was nullified on that ground. And then 2019, he presented another certificate this time around, which is not forged. And his opponent went to court saying that in 2011, the court heard that the certificate you presented was forged. The court did hear that the certificate you presented was forged, and on that ground, your election was nullified. Now you are presenting a real certificate that is not forged, but in the court, when they asked, have you ever presented a forged certificate? You said no. You have ever presented a forged certificate before. You presented a forged certificate adhered by the court in 2015. So the court decided, the Supreme Court decided that having presented a forged certificate before in 2015, he cannot be allowed to reap the benefit because the court decided that the certificate he presented in 2015 was forged. And so that he cannot be allowed to reap the benefit now. But in the year 2022, the same Supreme Court departed and distinguished that judgment from the judgment of Sheriff Oboroweri, the current governor of Delta State, that the fact that this man presented some document in 2003 or so to stand for election, and now you cannot just allege and plead those documents because in that case, the courts did not hold those Oboroweri's documents to be forged. So those documents that you are alleging, the court distinguished between that Ada's case and the current case. That in Ada's case, a court of appeal had heard those documents to be forged, those previous documents to be forged. But in Oboroweri's case, no court had heard that those documents were forged. And that forgery being a criminal offense that you need to prove beyond reasonable doubt. So, but Atiku's case is resting on Ada's case. So that's why I said we learn every day, and the law is what the court says it is. So we wait to see what the Supreme Court will say this one is, and then we also learn from there and take it up from there.
Quite interesting, Liborous. And now that you've brought in the preceding cases, can we talk about some other ones that Atiku was cited in asking the Supreme Court to grant him leave, to file his fresh evidence? He cites other cases like Amechi versus INEC, the famous Amechi versus INEC from 2008. Also cites Obi versus INEC from 2007, another famous case. Can you just throw some light on these cases and how they relate to the arguments over granting leave to the appellant to file fresh evidence, particularly as it relates
in those two cases?
Yes, particularly as it relates to the principle of ubi jus, ibi remedium.
These are two different issues. The principle of ubi jus, ibi remedium has to do with where there is a right, there is a remedy. Where a right exists and that right had been breached, then a remedy must avail that person whose right has been breached. What the question now is, in Amechi's case, Amechi was validly nominated as his candidate, the governorship candidate of the PDP in Rivers State. And the party, PDP, substituted Amechi without recourse to the extant law, that's the Electoral Act, and substituted Amechi with Omehia without recourse to the law. And the Supreme Court said no, that once a candidate is nominated, you cannot substitute that candidate except the candidate voluntarily, resigns or he dies. And against that backdrop, Amechi's substitution was illegal. And the court now went further, since the election had been conducted, that the mandate belongs to the political party. And since the mandate belongs to the political party, whoever inherits the candidature of that party will inherit the vote at the poll. Even though the Electoral Act was subsequently amended, that if you did not participate in the process, you cannot inherit any vote. The highest the court can do is to ask that parties go and redo the election. In the case of Peter Obi's case has to do with the court vacating a sitting governor on grounds of the fact that the elections were irregular. The substantial non-compliance had been proved. So these two cases are completely different from a situation where fresh evidence is admitted. These cases, including, in fact, the three cases I cited, all borders on, one, the right of a candidate that has been substituted illegally. Secondly, a candidate whose certificate the court previously had held to be forged. And this certificate, this matter were not pleaded as, fresh evidence at the higher court. The case of Obi also was the inherent power of the court to remove a sitting governor. So all of these cases had no bearing with adducing fresh evidence at the Superior Court.
Quite interesting, helping us understand the Latin maxim there. But Bola Tinubu had urged the Supreme Court to dismiss Atiku's application. In his response to Atiku's application for leave to file fresh evidence, he described Atiku's application as a crass abuse of court process. Atiku, however, in his reply, is suggesting that refusing to grant him the leave would amount to undue technicality. So let's talk about the issue of technicality. It's been a big topic. I'm sure you've talked about it a number of times in political cases in Nigeria. Liborous, how does the legal system, balance technicalities, the need for technicalities, with the pursuit of justice?
See, quickly, sorry. The cause of justice here, I think a lot of people are misinterpreting this technicality. So technicality has become such a bogus word now that people just think that once a court decides a matter that and it doesn't favor some, certain opinion, then the court's decision is based on technicality. No, I need to explain that there are the electoral jurisprudence in Nigeria. There are laid down rules, and these rules must be complied with strictly. For example, the fact that the law says you must file your petition within 21 days. Failure to file that petition within 21 days, the court will no longer deal with that petition. As distinct from the regular court where you can ask for extension of time within which to file. That does not mean that the court is dealing with technicality, because in a normal civil and criminal matter, the procedures for handling those matters, for dealing with those matters, is different. The rule is different. In electoral matters, the rule is different and applies strictly. The fact that the rule is different in an electoral matter does not mean that it is technicality. What the court is doing is applying the rule. Where you say technicality, let me give you an instance. In civil matter, it allows room for extension of time. In electoral matter, no law permits you to extend time. There is no law. Otherwise, when it gets on appeal, the Supreme Court or the Court of Appeal will just throw away the matter and said, this extension is not founded on any law. So in a civil matter, the rule is that when there is an application to cure a defect, and when there is a defect and there is an application to cure it, and there is an application to strike out that case, it is better for you to take the application to cure the defect first. That is the civil matter. But in in electoral matter, there is no such rule. There is no such latitude. That does not mean that the rule or the court is pandering to technicality. What it means is that there is no room for the court to exercise discretion, just the same way it is in civil cases. So in this case, if a party, for example, is asking court, don't, what do you call it, that you should not decide the matter on the basis of technicality.
But on the case of justice, pleading for justice over technicality.
What the party is simply saying is against the party. You are telling the person, the party, the court, deal with this matter on the basis of justice. And the justice demands that the law applies, the court applies the rule strictly without pandering to what do you call it, sentiment or emotions. So a situation where the court had to deal with the matter strictly on the basis of justice, that means the law must be applied to its letters. And that is the law that deals with electoral matters. So when you now say don't pander to technicality, you're actually telling the court, don't do what I'm asking you to do. Do justice. Don't allow this pressure.
Yeah, but Liborous, permit me to bring this in. If we go back to the questions that were posed to the Honorable Justice Tanko Mohammed, Chief Justice of Nigeria, during the Senate hearing on the confirmation of Chief Justice designate, Senator Enyinnaya Baribe had confronted the CJN designate with the pronouncement of the Supreme Court in the case of Akeredolu versus Abraham and others, 2018, where the Supreme Court in that case had said, quote, technicality in the administration of justice shuts out justice. It says a man denied justice on any ground, much less a technical ground, grudges the administration of justice. It is therefore better to have a case heard and determined on merit than to leave the court with a shield of victory obtained on mere technicalities. End of quote.
The question I will now ask you now, the question we need to answer is, what is technicality in civil matter? Is it the same thing as what is technicality in electoral matter? The answer is no. They are not the same thing.
But this was what the Supreme Court said in that case. So Akeredolu versus Abraham and others.
Me, please listen to me. You are talking about technicality. You need to define what is technicality. Did the Supreme Court define technicality there? The answer is no. You need to define what is technicality in this case. Technicality is not in abeyance. Technicality on the matter, on the fact of the matter. So it is not something you just hold, somewhere and say, oh, this is technicality. Each case is decided on each technicality on a matter is viewed from the fact and the dealings of the case. I gave you an instance. In civil matter, for example, you are allowed to amend. The rule allows you to amend. When a court refuses you to amend in a civil matter, that is technicality. The court shutting you out, saying, no, you're out of time, even though you have brought an application.
So Liborous, isn't Abubakar saying, therefore, because case, you said there is nothing like
will you listen to me, please?
Okay,
please,
I want to ask a follow-up question.
For the benefit of our listeners.
Go on.
For the benefit of our viewers, sorry.
Go on.
In that case, when the court refuses you in a civil matter an application for amendments, that is technicality. The court has decided the case on the basis of technicality. But in electoral matter, the court cannot even grant you an amendment because the law refused you to amend. When a court refuses you amendment in an electoral matter, that is not technicality. So you need to understand these two issues. So when people talk about technicality, they just talk. I give you an instance. If you do not file your reply in electoral matter within a specific time, you are shut out. You can't come back. But in civil matter, you can file an application for extension of time. In electoral matter, If you don't file your pre-trial notice within 11 days, your petition is deemed abandoned. That is the rule. But in a civil matter, if you don't file your pre-trial notice within a specific time, you can still bring an application. And if the court refuses you, that means the matter is decided on technicality. But in electoral matter, the rule is strict. And that does not mean, your refusing you does not mean that the court is deciding it on technicality. So we need to understand the word technicality as it applies to each case before you say, oh, this is technicality. That's why I'm telling you, asking a court, an electoral court, not to decide an issue on the basis of technicality but justice, when you are asking the court to deal with a matter on technical ground, is actually telling the court to shut you out.
Can you help us relate to the case of Demola versus Oyetola? Because that was one of the most, in recent time, most controversial cases that brought up a debate of technicality versus merit or justice.
What did the court decide in that case? In electoral matter, in that case, what the Court of Appeal, the Court of First Instance decided was that the issue, the results submitted by INEC, that there were 3 conflicting results submitted by INEC, and that INEC gave one to APC immediately a day after the election, and the other result that was printed from the Beavers 10 days after stated a conflicting result figure, and the third one that INEC attached to their respondent brief also stated a different figure. And the Supreme Court said, for you to reconcile all of these figures, that the IREV is a viewing portal. For you to reconcile all of these figures, you must have recourse to the Beavers. And that you must have recourse to the Beavers, so that you don't begin to dwell on the technicality of the matter because you do not have conclusive evidence from the back end. But when you go to the primary source of evidence, and that is why in law we say when there is conflicting report from secondary source, you have recourse to the primary source. The primary source in this case was the Beavers. The court, having recourse to the primary source of evidence, did hold that there was no overvoting that would have warranted Oyetola defeating the current governor. So those are the facts of that case. So when people make mention Adeleke, so when people make mention of technicality, it's just like a lot of people don't even know the definition of technicality in law. So they just say technicality, because you hear lawyers talk about it.
I wish we had more time to go into this, Liborous, because I know that there are several instances that we can look at. I've seen some material from the Justice.
Let me also quickly give you a scenario.
We're out of time, Liborous.
Just a few seconds, please. Let me also give you a scenario. Take the case of Kano. Kano, for example. Kano, two of the judges heard that the the respondent did not, the appellant, the petitioner did not file their pre-trial notice within time.
Okay.
And so, not filing that pre-trial notice within time amounts to abandonment of the petition. But if it were a regular case, your normal civil case, that wouldn't have been the decision, because in your normal civil cases, you are allowed for extension of time, unlike in election matters. All
right, so election cases are special. I think you lawyers have a name you call it.
That's why they are calling them, that's why we call them sui generis.
Sui generis. Thank you very much. Liborous Oshoma, we'll do this again. Thank you very much for your time.
My pleasure.